on the record in Schlitt versus Furlow. This is file number 2514862. I will ask counsel, starting with plaintiff, to put your appearances on today, please.
Thank you, Your Honor. Paige Graves here for the plaintiff, Mr. Schlitt.
Pete Boyles for defendant Al Furlow.
And Scott Malott for defendant Hertz.
Okay, this is, looks like, I believe, an initial scheduling conference in this case today. I mean, Mr. Graves, can you just kind of give me a little thumbnail sketch of your claims and kind of what you'd like to see going forward in terms of scheduling?
Sure, Your Honor. It's your basic ham and egg auto case. Defendant Furlow was driving a rent-a-car at the time. There was an accident involving my client. He sustained some shoulder injuries that we allege they meet the threshold. So I'll defer to Pete and Scott as to how much time they need for discovery, IMEs, and record gathering. And I would ask for mediation first. And if that doesn't allow a resolution, that we let you know and come back and ask for case eval if need be.
Okay, all right. Mr. Boyles?
Yeah, I mean, Your Honor, it'd be great to have 180 days. I don't mean to, it seems like it takes forever to get records, but I'm all for trying to mediate it sooner rather than later. Try and resolve it. Paige, quick question. What was your PIP coverage?
I'd have to dig into the file.
Okay, no problem.
Yeah, I'm fine with
Mr.
that. I'm fine with that same timeline of 180 days and mediate before case evaluation. Sounds good to me. I just filed my answer last week. I don't really know anything about the case yet, so it's all learning for me from here.
Sure.
Progressive,
Okay.
Peter.
And was it unlimited?
Oh, I'm just looking at the carrier. I didn't.
Oh, okay. No problem.
To answer your question, whether or not it was capped or unlimited, we'll both have to dig and figure that out.
Okay. I didn't mean to put you on the spot, Paige. I just,
Okay.
yeah.
All right, to the defendant's counsel, do we have everybody in that needs to be in? Is there anything that either of you foresee needing to change about pleadings at this point? I know, Mr. Malott, you're just getting into it, but.
Well, Your Honor, in lieu of Peter's question, if there's an issue of cap benefits or Medicare opt-out, we'll have to maybe tweak the damage part of the complaint to say excess economic allowed by the statute. It would just be a housekeeping amendment only.
Yeah.
Okay.
And I know Scott had a question is whether or not this is bench or jury.
I think we filed a jury demand last week. I called the clerk, and there had not been a jury demand filed, I believe, and we filed one with our answer.
Okay.
Okay, so I will put into the scheduling order that discovery will remain open for 180 days. I will order that mediation occur within that 180 days. So I'll leave it up to counsel to schedule that at a time that you all think is appropriate, given the status of your discovery and when you're all at a position where you think it would be meaningful. In the pretrial order, it will require you to confer and agree on a mediator. Do you think that you all will be able to do that, agree on somebody?
Yeah, how about Matt Coffey?
That's fine.
Yeah,
that'd be great.
Okay.
We got Matt. Plaintiff
So
counsel, I'll take the lead and notify Mr. Coffey of that, Your Honor.
all right, that was gonna be my next thing is I'll request if you guys, once you've reached agreement, it sounds like you have, if you can notify the mediator of his or her selection, and then notify the court of that selection as well in writing. And then I will set this for a status conference following the close of discovery. If the case has not settled by that time, then we can talk about dispositive motion cutoffs, further ADR if that's something the parties think is going to be helpful, and a potential trial schedule. But we can address all of that at that next status conference. Mr. Graves, is there anything else that I can address for you in terms of scheduling?
No, thank you.
Your
Mr.
Honor,
Boyles?
this is Pete Boyles. Yeah. I just, if we could reserve the right to have an IME if that needs to be in the order.
Okay,
Just as a precautionary thing. I rarely do them.
sure. Mr. Milata, anything further from your side?
I don't think so. Paige, if you can send over a demand and whatever records you have sooner rather than later, maybe we can just figure it out.
Yep.
Okay, I will send out a scheduling order reflecting what we've discussed today. I will also send out a notice of date and time for that status conference at the close of discovery, and you're all free to disconnect. Thank you.
Thanks, Judge.
Thank you,
Thank you,
Your Honor.
Judge.
Thanks, guys.
You guys.
Oh, I can take it.
Okay, thank you. Thanks, guys. Have a good day.
Thank you.
Thanks.
You're good. Sir, can you tell me your name, please? Or ma'am, whoever it is?
You.
Phoebe Hazy.
Okay, very good. Thank you. Just 1 minute. I'm going to get started with your hearing here. All right, Mr. Cleaborn, if you can unmute, please. And we'll go on the record in Hazy versus Kraft. This is file number 2514827. And record should reflect Mr. Cleaborn is present today on behalf of plaintiff. Plaintiff is also present both by Zoom. This is the date and time set for entry of a judgment to quiet title. And Mr. Cleaborn, is there anything you want to state in support of your motion to enter this judgment here today?
Yeah, good afternoon, Your Honor. Thank you. May it please the court. The plaintiff is the daughter of one of the deceased defendants, Cecil Kraft. And so essentially, since Cecil was the last one to die in 2005, the family have been paying the taxes on the property. There is a next door neighbor across the street that would like to purchase the property. And so the plaintiff, Phoebe Haas, agreed to be, I'll call it lead dog, so they could acquire good title to the property and then sell it to the next door neighbor across the street. Pretty routine quiet title action.
Okay. I did have a chance to review the file prior to the hearing today, along with the motion and the proposed judgment. I would note for the record that this hearing was set for 2 o'clock. It's now 2:05. No one has appeared remotely or here in person in the courtroom to challenge entry of the judgment or challenge the motion. Based on all the information contained within the file, the court finds it would be appropriate to enter that at this time. So, Mr. Cleaborn, I'm signing that judgment with today's date. Is there anything else that I can address for your side while we're on the record today?
I appreciate that, Your Honor. We are going to need to get a certified one, so I will be happy to send a check for that amount to the court clerk if you just make a note to have the clerk certify one, because we do need to record one to perfect the chain of title.
Okay, the clerk's indicating that she will do that, and that's all we have for today. Thank you.
Very good. Thank you, Your Honor. Take care.
Thank you. Okay, Ms. Anderson, you're appearing on the Morrison matter, is that correct?
Your Honor, good afternoon.
Okay, so we'll go on the record in Morrison versus Morrison. This is file number 2514907. The record should reflect that, let's see, Mr. Morrison, can you unmute for me? All right.
Is that okay?
I just want to, yes, it is. Just want to confirm for the record, you're Robert Morrison, is that correct?
Yes.
Okay, so we're on the record here today for purposes of a status conference in this divorce matter. Let's see, Miss Anderson, on behalf of the defendant, have you had any discussions with Mr. Morrison?
I have not, Your Honor.
Okay. So, Mr. Morrison, what I typically do at these pretrial hearings is try to determine what kind of issues there are in the case, what types of property may be in dispute, whether or not there's been any agreements regarding the division of any assets or debts, so that I can determine what's appropriate in terms of scheduling going forward. So from your side of things, can you address that for me?
I don't know what she's trying to do. I'm got a domestic violence against me, which is I was supposed to go to court on the 6th and they moved it to December. So I can't get a lawyer. They won't let me have a lawyer because they apparently think that I'm guilty. And I don't know what, I haven't contacted her. She sent me a narcissist message 2 days ago, but I can't contact her, so I haven't talked to her in 2.5 months.
Okay. All right, Ms. Anderson, where is your client at with this?
Your Honor, at this point, you can see by our counterclaim, my client is asking for some form of temporary spousal support. She is still in the marital home, but is trying to move so that Mr. Morrison can return to the home as it was his prior to the marriage, and we're not disputing that. So we do have some property to discuss, be happy to do mediation, and I want to see if I have a phone number for him. And if Mr. Morrison's willing to speak to me, I'm happy to do that and see if we can work out something to make this go quickly and smoothly and be done with it. Let me just check and see if I was provided a phone number for him. Can I confirm with you, Mr. Morrison, does your phone number end in 1911?
No. It ends in hang on a minute, new phone.
Well, I don't,
No.
I'm not, what it ends in isn't going to help me, and I don't really want you to state it over a live streamed. Do you have an email I could use to contact you? Or could I provide you with my phone number?
Actually, the phone is in her name, and so I probably do. Yes, I do. Yeah, that phone's fine.
The 1911?
Yes,
Okay, so can I give you a call and we can discuss maybe how we can work this out, and then I will have a way to contact you when she is moved out of the home so that you can
Certainly.
return back to the area.
yes, ma'am.
Okay, so at this point, Your Honor, I guess I won't ask for mediation at this stage, and we'll see what we can work out.
Well, here's what I'm going to do. I'm going to have discovery to remain open for the next 60 days. And I'm going to order that mediation occur within that 60 days. I think that would give you time for the two of you to talk and reach an agreement without having to go. But if not, then that gives us a deadline. And Ms. Anderson, I'm going to ask that if you're not able to reach agreement, that you contact community mediation to set up the mediation, and then they will follow up with Mr. Morrison.
That sounds fair, Your Honor. Thank you.
And then I'll set this for another status conference at about 60 days. If we haven't reached a resolution, then Mr. Morrison, I'll be able to check in with you and Ms. Morrison's attorney, Ms. Anderson, and see where we're at. So the court will send out notice of the date and time of that next one. If you are able to reach agreement, then we can use that date to enter a final judgment of divorce. Mr. Morrison, do you have any questions at all?
No, I don't. Nope.
Okay, Ms. Anything else I can address for your side?
I think we're all set for today, Your Honor. Thank you very much.
Okay, thank you. You're both free to disconnect at this time.
Oh, okay. Thank you.
Thank you.
Sir.
Yes.
I'm currently living with my daughter in Kalamazoo, and my mail goes to Rapid City. Will it if the mail gets there will I have time for someone to someone picks my mail up right now? And if it gets there, and they pick it up, do they have time to send it to me so I can look at it?
Yes, that should not be a problem.
So I don't miss my court date, I guess that's what I'm trying to say. So it gets there a
Yes,
couple
that should
weeks
be-
early?
Oh, yeah, for sure. We'll send that out relatively quickly, so you should get that in plenty of time for that kind of transfer to occur.
Okay, great. All right, thank you.
Okay, thank you.
All right, good night.
Bye.
Bye.
Miss Moore, are you Valerie Morrison? You're gonna need to unmute.
Yes, I'm Valerie Morrison.
Okay, Miss Morrison, we've already had your hearing. It was scheduled for 2 o'clock, but your
I
attorney
was sitting
did.
here holding the phone. I thought I was waiting. It said I was in a meeting and I was holding the phone the whole time. Darn
Yeah,
it.
didn't show up, but your attorney was present, so you can call your lawyer and she can fill you in on what happened.
Oh my goodness. I'm sorry, sir. I just now went back to try to figure out what was going on because it was so late, but I will do that.
Okay, no problem.
Okay, thank you. This is my first time ever using it, so I I thought I had it figured out. Apparently not, but you have a good day and thank you.
Okay, no problem. Thank you.
Bye-bye.
Okay, ma'am, can you tell me your name, please?
Silver Broadicum.
Okay, we'll go on the record in Broadicum versus Broadicum. This is file number 2514854. The record should reflect that Ms. Broadicum is present today by Zoom video. I have this as the date and time set to enter a default judgment of divorce. Ms. Broadicum, is that how you wanted to proceed?
Yes, I do have James texting me because he can't get in. I don't know if that makes a difference.
Because he's been defaulted, it really doesn't, and I don't see him in my Zoom waiting room right now. So if you're prepared to go forward, I can do that.
Okay, can I let him know that you said it's okay, that he's not, that it's a default?
Yes.
Okay, just a second. All right, just let him know. Yes, I wish to proceed.
Okay, so I'm going to place you under oath. There's a series of questions that I need to ask you. Those are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you'd raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Ms. Broadicum, you filed a complaint for divorce in this matter and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
It is true, yes.
Does that remain true today?
It does.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And in terms of personal property, things that you own, have you already divided that all up between the two of you?
We're working on it. It has not been completed. Part of that solution is waiting for the divorce decree today so that he can transfer his stock options to me.
Okay, but I'm just talking about things, not
yeah.
the stock yet.
Yeah, those are all
Okay.
good.
Okay. There's no disputes over how to divide up those things between the two of you.
No.
Okay. All right, and then in terms of the stock retirement, it looks like from what you've written in here that Mr. Broadicum is going to keep the residence, the marital home, is that right?
Yes.
And in exchange for that, he's going to give you his retirement benefits, is that correct?
Correct.
Is there a percentage or is it going to be his entire retirement benefits?
His entire stock. It's an ESOP, so an employee stock option.
Okay, understood. Couple questions. Is the marital home, the residence that Mr. Broadicum is going to receive, is that something that you own jointly?
No. No,
Okay.
my name is on the deed. He's financed it.
Okay, so your name is not associated with any of the debt?
No.
And are you going to quit claim your interest in him then as part of this transaction?
Yes.
Okay. I'm just going to write that into your judgment so that that's clear. Do you have any objection to that?
No.
Okay. So I just wrote in that plaintiff, meaning you, will quitclaim her interest in the marital home. And I'm just initialing that, so it's clear that I wrote that in today.
Okay.
Okay, aside from what we discussed, are there any other issues regarding the division of any assets or debts of the marriage?
No.
Are you asking to have your last name changed?
Yes.
Okay, and that's to Carlson, as you've indicated here on this proposed judgment.
Correct.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Browdigan. The court, after reviewing the file, notes that Mr. Browdigan was properly served with the summons and complaint. He did not file an answer or otherwise defend. He was defaulted and provided notice of that default, as well as notice of the date and time of today's hearing. And has had the opportunity to connect, but has not. So the court will enter that judgment. I've signed your judgment of divorce with today's date. So your divorce is final as of today. That also means, Ms. Browdigan, that your name will be legally changed going forward. So make sure that you get a copy of this judgment for your record so that you can change your identification and other documents, okay?
Okay, and how do I get a copy of that? Will it be available at what court?
Here in Kalkaska at the circuit court, you can call the clerk's office to get a copy of that.
Okay, thank you.
Did you have any other questions?
I do not.
Okay, all right, thank you. That's all for today, and you're free to disconnect.
Thank you.
Okay, looks like we've got everybody connected, so we'll go on the record in Tuttle versus Kalkaska County Road Commission. This is file number 2514686. If I could have counsel put your appearances on, please.
Good afternoon, Judge Kevin Cowan on behalf of defendant Kalkaska County Road Commission.
Mr. Tuttle, you're muted.
No. That better?
Yes.
Robert Tuttle for the plaintiffs.
All right, thank you. We're on the record here today. The plaintiffs have filed a motion to preclude the defendant from introducing expert testimony. I had an opportunity to review plaintiff's motion and brief, as well as the defendant's response. Mr. Tuttle, anything that you wanted to present today by way of oral argument?
Well, the entry point is they still have not answered interrogatory 7. And they say that at the end of their brief that their expert witness is this Rebecca Rivard. If they've known that for months, why didn't they answer interrogatory 7? They still haven't answered it. And interrogatory 7 has 4 subparts. Substance of the facts and opinions in which the expert is expected to testify, a summary of the grounds for each opinion, and the qualifications of the expert. We don't know any of that. And they've identified this woman, but from all I can tell, she's just a staff engineer. They've held her back until now in discovery.
Okay, so based on their failure to answer interrogatory 7, you're asking the court to exclude her, or what are you asking the court to exclude?
All expert testimony. They should have
including Ms.
Yes, and Ms. Rivard. Yes, sir.
Okay. All right. Thank you. Mr. Cowan?
Yeah, Judge, it's simply a drastic request here. Ms. Rivard was first identified in defendant's initial disclosures all the way back 5 months ago, where the defendant wrote, the Road Commission intends to call Rebecca Rivard, professional engineer, in support of its defense of this trial. That was straight from our initial disclosures under the subheading of anticipated areas of expert testimony. Plaintiff's motion in this case fails to rely on any authority at all. It's simply copy and paste the court rule and ask the court to impose a drastic sanction when in fact there are several factors that the court has to analyze to exclude any expert testimony, which in this case, plaintiff failed to either point out or identify in their motion, and all the factors in these cases don't warrant the type of drastic sanction that plaintiffs are even searching for here. The matter of the fact is that Ms. Rivard was identified 5 months ago. Discovery is still open and there is no trial date set. So if truly all plaintiffs are actually asking for are supplemental discovery answers, defendants are willing to do that. But in direct response to the motion, plaintiff failed to identify the factors that the court has to analyze to even assess a motion like this. And the factors as laid out in our brief aren't satisfied anyway. So defendant would ask that this motion be denied.
Thank you. Mr. Tuttle, anything you wanted to say in response?
Well, if they knew 5 months ago that Ms. Rivard was going to be an expert that they were going to call, why didn't they answer interrogatory 7? I don't like getting sandbagged and late disclosure, last minute disclosure. If I hadn't filed this motion, they still wouldn't have repealed her. And in terms of the authority for our motion, I cited this case and I attached a copy, LaCourse v. Gupta, which is almost on all fours, where somebody did not identify their expert witnesses. The court said, I'm going to exclude them. And then when it excluded them, it granted summary disposition for the against the disobedient party. But at bottom, they can't explain why they sat on this for 5 months. And if you look at document request number 23, which is exhibit 2 to our motion, we asked for the CVs of any experts they're going to present at trial. Now they did produce hers, but they didn't identify her as an expert. In fact, they disclaimed that they had picked an expert. Expressly disclaimed it, said we haven't picked an expert. So I think they're kind of gaming with the discovery in this case, Judge. And we do have great authority, almost all on all fours, LaCourse versus Gupta.
All right, Mr. Gowan, Cowan, I'm sorry, are you aware whether you're at this point going to call any other experts other than potentially Ms. Rivard?
I'm not aware, Judge. As the caption indicates, Mr. Tuntis is the lead trial counsel in this case. I'm covering this hearing for him. I know that Ms. Rivard is going to be the lead expert in this case. As far as other experts, I'm just not aware at this time.
All right. So again, I had a chance to review the briefs, and it looks like the defendants did disclose Ms. Rivard as part of their initial disclosure. So the fact that she's been identified as an expert, I think, isn't in dispute. So both sides have known that she was a potential expert that the defendants would call. The defense have indicated at this time that they're not going to call any additional experts, so there isn't anybody for me to strike. To the extent that the defendants do identify experts later on, then I think that would be subject to a challenge. In terms of Ms. Rivard, though, there's no reason to exclude Ms. Rivard. Again, she was identified early on in the case as a potential expert. I do think to the extent, and it appears to me that the defendants did disclose her CV to the plaintiffs, so they've been provided with that information, so that's not a basis. I think to the extent that their initial disclosure did not fully answer interrogatory number 7, then I think supplementation would be appropriate. And so, Mr. Cowan, I'm going to require that your client, to the extent that the initial disclosure identifying Ms. Rivard and explaining her involvement doesn't fully answer interrogatory number 7, then the court will require a supplementation of that within the next 30 days. But other than that, again, without any other experts having been identified, there essentially isn't anything for the court to strike at this time. So the court will grant the motion to the extent that defendants will be required to supplement interrogatory number 7, but deny the motion outside of that. And Mr. Tuttle, I would just request that you prepare an order that reflects that ruling and submit that to the court under the 7-day rule.
I got it, Your Honor.
Okay. All right. Thank you. That's all I have for this hearing today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Thanks, Judge.
Terry, can you just check the lobby and see if there's anybody out there? We had also at 2:30 that PPO. Can you the title files back? Starting to grow.
What's that?
Starting to grow.
Yeah.
There's nobody there. Okay. Court will call the matter of Johns versus Johns. This is file number 2514816. This was set for a show cause hearing on an alleged violation of the personal protection order. The hearing was set for 2:30. It's now at 2:42. Nobody's present in the courtroom or on Zoom. This was set as an in-person hearing. I just asked the court officer to check the lobby. Nobody is out in the lobby on this case, so the court will dismiss the show cause, and no further hearings will be scheduled. Okay, we'll go on the record in Cold Springs Township versus DSV. This is file number 2414452. Mr. Jaskowski, if you could just put your appearance on, please.
Thank you, Your Honor. Good afternoon. Richard Jaskowski appearing on behalf of Plaintiff Cold Springs Township.
All right, thank you. We're on the record today for a motion on behalf of Cold Springs. I had a chance to review your motion, Mr. Jaskowski, and it sounds like what you're asking for is just an order from the court, essentially enforcing the judgment, default judgment that was entered against the defendant, and pursuant to that default judgment and statute, some attorney fees and costs. Is there anything that you wanted to state and support that motion today for the record?
No, Your Honor, we would rely upon the written motion, and the purpose of this motion, as the court indicated, was simply to provide another opportunity of notice to the defendant that this estimate of $8,500 to $15,000 in cleanup and removal costs is, if granted by the court, is likely to be incurred by the township, and then a bill sent to the defendant. If it's not paid, that would be placed upon the tax rolls for their property in conjunction with attorney fees of $751.25. And again, simply letting the defendant know that their items of that are causing the nuisance and the blight on the property would be removed and disposed of as indicated in the proposed order. So again, we're simply relying on the motion and the written order to provide one last opportunity of notice to the defendants.
All right, thank you. So first of all, I do want to note for the record, this hearing was set for 3 o'clock. It's now 3:07 by my clock. Nobody on behalf of the defendant has appeared either remotely or here in the courtroom physically today. I did review the default judgment that was entered back in August of 2024. It does require the defendant to remediate or abate the conditions that were causing the nuisance that resulted in the judgment. And the judgment also provides that the plaintiff, Cold Springs Township, can tax any and all costs necessitated in enforcement of the order. So I find that the motion is in compliance and authorized by the judgment that was entered by this case or by the court. So I will sign that order today. And Mr. Jaskowski, anything else I can address for your side while we're on the record today?
No, Your Honor, thank you, and have a good day.
Okay, thank you, you too. And all parties on this case are free to disconnect at this time. That concludes the court's afternoon docket. The court will be in recess until 9.